Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Yesterday, we came to know that the controversial Hijab versus turban issue in Karnataka state has been referred to the larger bench because the matters of constitution relating to the religion and some seminal things are concerned there. Actually, I have been waiting for the verdict of the Karnataka High Court. As the trouble between the two communities or two religions have been simmering, and it has gone to the stage of declaring holidays by the Karnataka Education Department. I don't want to foment the trouble. I want to speak only in the legal manner. What legal points are involved, that's all. We don't want to go to the, I don't want to politicize the issue. I don't want to go to the merits or demerits of this thing. To begin with, it all started on 31st December 2021 that Muslim students in Udupi Pre-University College, they have given a complaint to the principal that the management or the same college is not allowing the hijab. Hijab, you know, is nothing but the scarf which covers the face. According to Muslim law, they say that they have to cover the face. Burqa is done, which is the black or a simple color dress worn by the Muslims. This is burqa on the head, that is hijab. It has started with the PUC college in Udupi. It extended to Kundapura, Shimoga, so many other places. So the particularly girl students who are wearing hijab, that is Muslim students, they insisted that they should come with only hijab, which is their fundamental right to wear the so-called head scarf. But rule number 5 of the education rules of Karnataka state, they have given autonomous powers to the institutions to prescribe the uniform they like. Now, the management say that they have to come in uniform. Of course, there are interference by the state also, as we came to know. But let us not dwell deep into the matter. Ultimately, this has become an issue. And Kumari stated 11 Muslim students. You can read the case as Reshma and another versus state of Karnataka. Right? So, they have filed a petition actually of writ of mandamus requesting the court to issue interim relief, that is interim directions to wear the hijab and attend the college, because they have to go to the college to learn the education, is it not? But the matter troubled. When these people were allowed with hijab, the students belonging to other community, Hindu, they are coming with the turbans and raising slogans, Jai Shri Ram. You might have heard you might have seen the video where the students actually they are running after a Muslim girl, and these people are saying Jai Shri Ram and she is Allahu Akbar. All these things, nuisance incident happened, and actually now Karnataka state is simmering with the problem. Anyway, since these people have filed the case, we expected that yesterday the judgment would have come, because the day before yesterday itself, Justice S. Krishna Dixit, he heard the matter, he reserved it, and yesterday he stated that since there are so many issues, constitutional issues pending, it is better to refer to the larger bench. That means he has referred the matter to the Chief Justice of Karnataka, who will in turn allot it to some other constitutional bench, and they will decide. It may take some time. In the meanwhile, High Court asked the teaching community, the student community to maintain peace and tranquility. So of course, the colleges were declared holidays, and therefore there may be some tranquility for this particular point of time. Now, what are the legal implications we have to discuss. So particularly the women students focused on Article 14 and also Article 25 of the Constitution of India. You all know what is Article 14, that is equality before law. Everybody is equal before law and the state should protect the laws. Whether he is a prime minister, whether he is a student, whether he is a lecturer, the rights should be protected without any hesitation. Let him be a high profile man, but he has to follow the law. That is the beauty of rule of law. Secondly, Article 25. Article 25 of the Constitution deals with freedom of conscience and free profession, practice and propagation of religion. This is the more important. So, practice, propagation and profession of religion. So, the word religion is not clearly defined, but whatever, in which faith you have got, you can profess, you can propagate and you can follow. Nobody should object. So, this is the, so since Article 25 has been violated, so please restrict the government of Karnataka or the education department and allow us to go to the college with the hijabs. Right. Now, the question before the court or issues, there are three issues which have come before the court. Number one, whether wearing of hijab is a part of Islamic faith or essential religious practice of Islam or not. Number two, whether the state can interfere in such religious matters, because ours is a secular state. In the preamble, we said it is secular. And third point, whether hijab is a right to expression under Article 19, and if so, is there any reasonable restriction under Article 19 clause 2? Right. So, High Court Justice Dixit says the matter requires consideration of a larger bench and they have to take into consideration the neighboring High Court judgments also. You may be knowing APIMT, that is some pre-medical dantlo mundu parikshadi. So in that connection, Kerala High Court stated that wearing of hijab is an essential religious practice of Muslims. So Kerala essential religious practice of Islam. So they asked the Muslim students to be allowed to appear for the APIMT examinations, maybe in the year 2018, I believe. At the same time, Madras High Court, they stated that parda is not an essential, but covering of head by the scarf is mandatory. So double. High Court, Madras High Court jatyavanandi. And parda mattam akkarledu, but covering of the head by the scarf, that is hijab, is mandatory. So kabatti, now the point is, suppose if you are an advocate on behalf of the Muslim students, so the advocate on behalf of the petitioners, he stated that so state has no power to interfere in such matters, to prescribe uniform. State has no competence to issue a GO on the dress code. But of course, the Advocate General, he opposed. He stated that each education institution has autonomous right in prescribing the uniform. So interim order. So these people asked for the interim orders to allow them to go to the college with hijabs. But AG said, if you give the interim order to allowing them, it is nothing but allowing them. So please wait, please give a clear decision. Right. So in the meanwhile, High Court appealed the students to have faith in the Constitution. Yes, it is Article 51A also says you must have faith in the Constitution and maintain peace and tranquility, because the matter is sub judice. Okay, so actually here AG also said one more, state actually doesn't want to interfere in this religious issue. They wanted to say only thing is they wanted to maintain the uniformity, the discipline and public order. That's all. We don't want whether you wear this uniform or that uniform. But when the college prescribes a uniform, you have to follow the uniform. So these are the legal intricacies in this hijab row. So please follow the larger bench, may give some decision. At that time, I will come back to you and inform the court's decision. Till now, this is the situation. So thank you very much. Bye.